Good morning, my electronic fellows. Today I will be discussing about chapter 3, who is client. Basically, client is a person who consult with paralegal on whose behalf the paralegal provide the legal services or agree to provide on the person's behalf. And the client is a person who, having consulted with the paralegal, reasonably conclude that the paralegal has agreed to provide legal services on the person's behalf. And basically, this is one of the paralegal most important duty to provide quality of services, quality of legal services to the client. What is the quality of services? That include the responsibility to be competent, to maintain client confidentiality, and to avoid conflict of interest. That is the quality of service. To be competent, maintain client confidentiality, and to avoid conflict of interest, and continue to represent the client unless there is a good cause to withdraw. Other responsibilities for duty of service, like fee, billing, and handling the money of the client. Another thing that's one term is prospective client. Who is prospective client? Basically, prospective client is not the client. Keep in mind, prospective client definition is any person that or individual organization seeking advice or assistance on a matter that paralegal professional knowledge, even though the paralegal has not retained or agreed to retain. That is prospective client. And prospective client has not revealed the confidential information that may or may not hire you. And paralegal additional duties that if he reveals the confidential information, then the paralegal has to provide that confidential information and avoid conflict of interest. When prospective client reveal the confidential information, that become the client. Before that, there were no additional responsibility for the paralegal to protect the confidential information or avoid conflict of interest, because he never revealed that information. And when prospective clients reveal confidential information, then it becomes the client, and paralegal agreed to provide legal services. And paralegal has to make sure whether the providing the legal service or not, because until you make it clear to the client that you have been hired by the paralegal and paralegal is going to provide legal service, the client will consider that he is now the client of the paralegal. To make this confusion clear, to avoid this situation, whether reasonably or unreasonably, the paralegal should confirm in writing with the client, either in engagement letter or non-engagement letter, that he is providing legal service or he will not be providing legal service. When there is a written document in your hand, you can say, yes, we did not agree to provide and you are not our client. So that's how it works. Another term is firm client. You are working in a firm. There are a lot of maybe 10, 100 clients in the same firm. So the firm clients or the paralegal partner with or associate with handle, even paralegal is not handling the other clients. He is working for his client, but other clients invariably they are also your clients. You have to take care of every client in the firm. Once the client contact, your client is contact, just say you are paralegal for, just say name, your client is John. John come in contact with you and you agree to provide the legal services. Now you will see the all information of your client, whether it conflict with the other clients of the firms for what you are working. Then you cannot handle that client because it's a conflict of interest. So you should keep in mind that to avoid conflict and representing the client within the firm and your client, you are protecting both clients' conflict of interest, and you have to make some sort of screening for conflict and the person file and office management system to see whether that client matter does not conflict with the other client matter. So if everything is fine, then you may continue to represent your client like you are working for the new client. And one more thing before agreeing to provide legal service, determine who is client. Even though it is apparent with the organization, individual or group of individual is the client, situation may arise during the retainer and may create the confusion. There are 3 people came in your office from the organization. First question is that who will provide the instructions? Who is my client? You 3 people are sitting and everybody belongs to the organization. You have to make it clear who is the client, who will provide me the instructions, so that I should follow the instruction from the particular person who is in contact with you and who want to be your client, and who is properly authorized to instruct the paralegal on the client's behalf. Sometimes your client is an organization and organization depute one person or agent that he's the person who will be providing you instruction to carry out the business for that organization. I'll come to that what is joint client, joint retainers, and what are the guidelines for the joint retainers. Joint retainer occurs where the paralegal have been retained by more than 2 clients in the same matter. Paralegal should clearly identify that with the client that whom the legal service will be provided to ensure that they can fulfill their duties according to the client requirement. Before accepting the joint retainer or joint client, you must ensure that there is no conflict. Always check for the conflict. When our client first contact, when our client contact again, during the retainer, whenever you sign an engagement, throughout all the phases you have to keep checking conflict of interest. It might change because whenever new client comes in, it might conflict with that new client, or whenever client gives you some more other instruction, that might conflict with the other clients. So conflict checking all the time. So before accepting the joint client, paralegal must advise each of the client some following points: that paralegal has been asked to act for both or all parties. You are acting for 2, 3, 4, whoever the joint clients are. You are working for all with the same level of expectation, and No information received about the matter of the joint client can be treated as a confidential with other clients. All clients' information should not be considered as a confidential bit among other clients and cannot be withheld from other clients in the matter in the joint retainer. And what if the 3 joint clients or more than 2-3 joint clients and conflict develops between those clients? Oh, what's gonna happen? Basically, conflict exists. There are some certain steps you have to follow. After being informed that either the paralegal cannot continue to act for both or all of them, or may have to withdraw. And after informed with the above, the paralegal may represent the joint client. Like paralegal has been retained for all clients, and no information should be treated as confidential among those. And if conflict developed, he may withdraw from the client, and paralegal who owes each client's duty of undivided loyalty. There are certain situations in joint clients when the conflict develop, and if the paralegal have a continuing relationship with one client and recommend the other client that other clients obtain independent legal advice if all parties agrees. Only in case all party agrees, if you have a continuing relationship with one party with the consent of all parties, you can continue with that client and ask other clients to take independent legal advice with the other paralegal or lawyer. Other situation is that if there are differing degrees of knowledge, vulnerability and authority among the clients, paralegal should consider suggesting that they obtain independent legal advice. Different degrees of knowledge, again ILA, independent legal advice. So again, in contentious issue arises between or among the clients, paralegal must not advise any of them on the contentious issue. If the contentious issue has arisen, paralegal should not advise any of them. And in such circumstances, paralegal must refer to the client to other paralegals if the legal advice is required. In contentious issue, if the legal advice is required, paralegal must refer to the clients to other paralegal or lawyers in respect of that contentious issue. And if no legal advice is required, there are 2 situations. If legal advice is required, paralegal must refer to clients for other paralegal or lawyer for ILA. And if no legal advice is required, another options. Advise them to have an option to settle the contentious issue by direct negotiation. Ask those 2, 3 or 4, whatever the client's numbers are, to resolve the issue by direct negotiation if the no legal advice is required. If they settle the dispute by direct negotiation, well and good. By their consent, you can continue to provide the legal services. But if the contentious issue is not resolved by the direct negotiation, paralegal must withdraw and finish by withdraw from representing the client. So there are some guidelines regarding the organization. When the paralegal is acting for the organization, paralegal should determine which officer, directors, shareholder, employee, agent of the organization may properly give instruction on the organization behalf, and this must be in writing. Okay, in writing. You are the person who will be giving me the instruction, well and good. Maintain that record in writing. Then there should be no confusion at all during your legal services. So another situation, if the paralegal is retained to act for both an organization and the officer, director, shareholder, employee, agent of an organization on the same matter. So there are two parties. One is organization, one is the client. That's a joint retainer. Basically, they are in a joint retainer, and you have to check the conflict of interest. If the conflict of interest exists, then the paralegal may not act for the both. And if no such conflict exists, they may continue to provide legal service for the both, and with the joint retainer rule. Sometimes there is a limited scope retainer. The paralegal and the client agreed to provide in limited scope. Sometimes the client says that I only need your services for Provincial Offence Act or for the ticketing. Rest other matters I don't want to hire you. So that is called limited scope retainer, that you are providing for legal services for limited services like small claim court or just POA matter. In this situation, paralegal should carefully assess it in circumstances, and paralegal must advise the client honestly, candidly about the matter, extent and scope of the services of the paralegal can provide, and where appropriate, whether he can provide the services within the financial means. Even in limited scope retainer, paralegal must also confirm in writing, engagement letter in writing, when practicable, and give copy of written document to the clients. You see that whenever you have a written confirmation that you will be only providing the legal service for POA matter, it is in writing, in engagement letter, and the copy will be given to the client. Another one important thing is unrepresented parties. Sometimes you are acting for your clients and another party comes in. This is another party and this is you. You are providing your clients, and another party is just unrepresented. He doesn't have any paralegal or lawyer. That unrepresented party is representing himself, and there are special obligation when representing the client in a matter where the another party is not represented. Paralegal must take care and take care that unrepresented parties not proceeding under impression that you are protecting the unrepresented party's interest also. Make it clear to that unrepresented party that you are not my client. I am not representing you. I am not acting for you. I am not in the interest of your things. I'm just acting for my client's interest. So that should be should make it clear, and accordingly paralegal comments may be partyism because you are party to your client. You are protecting your client interest, not the unrepresented party. When the unrepresented party will be advised accordingly, then he will think that you are not the person who will protect my rights or protect me or help me. You are against that party. You cannot protect him. That is unrepresented party's responsibility. You have to tell them. Client identification and verification. Now, you have agreed to provide legal services. You have made engagement, non-engagement letter when you are agreed, and now the next step is client identification and verification. And these are the requirement by Law 7, Part 3. For the purpose of these requirements, the identification referred to as obtaining a process of obtaining and recording basic identification information, basic identifying information the paralegal needs about the client, not and any third party when retained to provide legal services, such as name and address. Client identification and verification requirement is obtaining the recording of basic information the paralegal needs about the client and the third party, and you have to comply those obligations. So identification it's a client information, name and address. Paralegal should consult, determine identification, verification, third parties required any circumstances. Certain procedures for identification and verification of individual and organizations. First, I will discuss about the individual. If the client is individual, and the paralegal must obtain the individual's full name, home address, phone number, business address, and the phone number if applicable. Identification of party who is individual: name, full name, first name, last name, middle name, home address, phone number. They are required. Full name and home address required, and the business address, phone number if applicable. So these are the essential things you need to record for the identification of individual. Identified, the next step is verifying the identity of a client or third party is individual. How would you verify? He gave you your name. My name is John Smith Colin, and my home address is 33 Tozer Crescent, Ajax, and if applicable, my business address is whatever it is. Now the next step is verifying the identity of individual. How will you verify the identity? He just gave you the information. Now you need to verify whether he's saying that I am John Smith. How will you prove it? The verification is required. So for the verification, the paralegal must use one of the following client verification method. One of the following. Number 1, government issued photo identification method. So examining the individual government identification document, excluding document issued by the municipal government. Note that regarding municipal government, what documents of photo identification of belongs to municipal government, like individual health card and other thing related to municipal government. Health card number, you cannot ask those things because these are not the valid document. And another thing is that client has some sort of confidential health record in the health card. You are not supposed to ask or take or make photocopy of health card. The only government issue identity photo identification is driver license or the passport. Another thing, this should be valid driver license, valid passport. These are the one thing. Another thing is method is credit file method. Information of the individual credit file that is located in Canada and has been existent for at least 3 years. Credit file method in Canada for 3 years, at least 3 years. So third process is dual process method. In dual process method, any two of the following piece of information, each of them is a different reliable source. Paralegal or individual acting on behalf of the paralegal. Information from the reliable source contain the individual name and address, like birth certificate or other thing. They have that's a reliable source. The individual name and address is on that birth certificate, and information contain that individual name confirm that have deposited account, credit card or other loan amount with the financial institution. So that's two of documents you can use as a like a bank statement or some other thing that your name is on that file, or some sort of bill, your name and address is on that document. You can use two of these documents. That is called dual process method. Fourth possible thing to verify the identity is virtual verification with authentication. This is new topic. The Law Society has added this topic, and it is very new. Before, in older books you may not find this topic, virtual verification with authentication method. Using video conferencing and the other form of virtual communication to meet the individual using a process or method of to authenticate the individual identification document remotely and confirm the document. The document is valid and current. For example, authentication of the individual identity of the document. Paralegal could view the original identification during the video. Okay, this is my driver license, this is my address, and this is all the information, and it is the date of birth and other things. So he's seeing in the video and use the technology to compare the identification document against known characteristics. The known characteristics, there are some marks. The paralegal lawyers know that these are the marks. They authenticate that document. So individual, their photo identification document virtually without. And as of January 1, 2024, verifying identity by viewing an individual and their government issue photo ID document virtually without authentication is not permitted. So authentication is required when you are doing virtual identification. So all these documents for verification, regardless of the method you have selected to verify the document and the record, must be authentic, valid and current, and the information must be valid and current. So you have to take care about that the document must be authentic, valid and current. So individual identification verification is done. Individual identification, full name, home address, and if applicable, business address, and verification of identities, government issued ID, photo ID, credit file method, dual process method, and virtual verification with authentication. It's done. Now identification and verification of when the client or third party is organization. Organization identification is verification is a little different from individual. For the organization, the paralegal must obtain organization full name, ABN Farmer Group, organization's business address and phone number. Before that, individual name and individual address. Now organization full name, organization business address and the phone number. A third thing is the name, position and contact information for each individual who is authorized to give instruction on behalf of organization with respect to the matter for which the paralegal is retained. Organization full name, organization business address, and the name, position, contact information for each individual who is authorized to give instructions. In addition, for organization other than the financial institution, like other than the banks or the financial institution, there are some other organization. Then there are some additional duties for the paralegal. Paralegal must obtain, if applicable, business information, business identification number. If the organization is corporation, then business identification number, BIN, and the place where it is issued. Because whenever some incorporations are working in a different area or cities, they have a BIN number, and they have in that BIN number where it was issued. So these two things, and information regarding the general nature of business. What are you doing? You're providing some sort of agriculture, you're providing some services, you are providing some transportation, or if it is incorporation, then business information number and the place where it is issued and the nature of the business or activities engaged in by the organization. So identification of organization is done. Organization full name, organization business address, and name, position of and contact information for each individual who is giving instructions. Now the second step for organization is verifying the identity of organization. So when the client or third party's organization, how to verify the identity. So how will you verify the identity of organization? Because organization is not a physical, entity. It's some sort, you cannot, it's not a human. So how will you verify the identity of organization? To verify the identity of organization and third party, the paralegal must also verify the identity of each individual giving instruction on behalf of organization. Basically, you will be verifying the identity of the individual working for the organization who is giving the instruction to the paralegal or lawyer. As you cannot verify the organization because it's not a human. So you will verify the identity of each individual giving instructions. And to verify the individual, it's the same method when verifying for individual using one of the client verification method you have used already to verify the individual. The thing is verifying the organization, that you need what type of documents and the information required to verify the identity of client or third party when it is organization depend on the nature and type of the organization. If the organization is incorporation or an organization is created or registered under federal or provincial laws, incorporated an organization created or registered under federal or provincial laws, paralegal must obtain written confirmation from the government registry of the organization existence, organization name and organization address. So if it is registered under federal or provincial laws, paralegal must obtain written confirmation, government registry of organization existence, name and address, including name of organization directors, if applicable. Example of such document and records include certificate of corporate status issued by the public body. Public body issued some incorporation to work in certain areas to carry out their business. They give some sort of license or something, certificate of corporation, and copy obtained from the public body of the record that organization file annually, such as an annual filing of the corporation. Copy of public body of the record that organization files annually. The third thing, a copy of similar record obtained from public body confirming organization existence. See, you have to make sure that the organization exists, and how it exists, if it is registered with the government registry, the name, address and organization's directors. About when it is registered, what if the corporation organization is not registered? There is another procedure when the client or third party organization that is not registered with the government registry, that is trust or partnership. They did not register with the government organization. Then they should obtain the copy of organization containing documents such as trust and partnership agreement, article of the association and the similar record. So when it is not registered, then you should take the agreement copy, article of the association and the similar record confirming organization existence. They must have with them when they form some sort of partnership or association to verify the organization existence. There is another process for verifying the client or third party of identity by use of agent. So bylaw 7 permit the paralegal to use an agent to verify the identity of the client or third party if prior to agent acting, the paralegal and the agent enter into written agreement, and it's only applicable if the client is within the Canada. If the client is outside Canada, then the agent cannot be used. So if it is outside of Canada, then you can verify the client by a credit file, dual process, or virtual verification method. So when using an agent, then again that information obtained by the agent should be valid, current, and complies with the requirement of bylaw 7. Okay, if the paralegal firm or agent have previously verified, if you have made identification of verification previously, maybe 6 months ago or 4 months ago, you carried out everything regarding that client and matter was over and they left. After that they again came in, and you have already previously identified and verified that client. So now do you again verify and identify and verify that client? No. If the paralegal previously complied the verification requirement and believe the accuracy and verification requirement have not been changed and current and valid, they can use that previous information and they don't have to verify again. So previously identification and verification, if it is current and valid, it can be used. No need to identify and verify again. So the record of identification and verification. The record of identification of verification, all copies for verification of information, documents used by agents, agreement, every record document should be maintained for such a duration, the professional relationship with the client, and for as long as necessary to provide the services to the client, and 6 years following the completion of work which the paralegal was retained. So this record should be kept for 6 years, and this information may be kept electronically only if the paper copy can be readily produced from it. One last thing in this chapter says that withdrawal obligation. So bylaw outline that whenever in course of identification and verification, the client is and third party, the paralegal must withdraw if he knows that the paralegal would be assistant client in fraud or other illegal conduct. Paralegal must immediately cease engaging in activities that would assist the client fraud or other illegal activities. And this obligation applies whether the paralegal is suspicion arises during the identification and verification of the process. At any time throughout the retainer, you came to know that this person is involved with some sort of illegal activities and somebody is behind him, and then you must seize everything, withdraw. Because under the paralegal rule, paralegal have the duty to withdraw in cases where the client conduct or proposed conduct is dishonest, fraudulent, criminal, or illegal, despite of paralegal advice that the client insisting to continue with such conduct. So you must withdraw for some sort of illegal. So this is the end of the chapter. Chapter 3 is done. I believe you will benefit with my this lecture. I am trying my level best to improve from time to time to share the knowledge and whatever in the books and what should be asked, because before preparation you must read each and everything thoroughly and keep on revising. First read the chapter and then just concentrate the key points. Revision is necessary. Thank you very much. See you in next chapter.